session on enforcement of intellectual property in China, organized by the China IP SME Helpdesk together with the Flanders-China Chamber of Commerce and EU-China Business Association. Maybe a couple of words about the help desk for the ones who don't know about it. Firstly, my name is Alessandra Capriglia, project manager of the China IP SME Helpdesk. You can find my contact details here. Very welcome to contact me for any follow-up question you might have. The help desk is a EU-funded initiative. We provide free initial advice to European SMEs on protection, management, and enforcement of intellectual property in China, and it's 4 jurisdictions, so mainland, Hong Kong, Macau, and Taiwan, each of them having a different IP system. So it's important to also know the differences within those 4 jurisdictions when going to China. Since 2008, we have helped hundreds of thousands of SMEs, and we keep doing this on a daily basis. And so whenever you need some support on IP protection, we're always there to support. And I would like to emphasize the fact that the service is continuous, which means that you can contact us even more than once, even after a few years. In terms of our services, the helpline is, of course, our most important service. We have an email address that you can write to us, sending all your inquiries, your questions about IP, and we respond within 3 working days, of course, in a very confidential way. In terms of other services, we provide training sessions like this one, both on-site and online. In case you have very concrete questions about your IP strategy in China, you can also schedule a one-on-one consultation session with our IP business advisor. It normally lasts 30 minutes to an hour, and you can really talk in depth about your situation. If you click on the website, if you visit our website, you will find a lot of self-learning materials such as IP guides, fact sheets about the different jurisdictions, infographics, and as well as case studies. So real cases of companies who contacted us, and you can learn how we supported them and how they dealt with their situation. And of course, we have also a blog where we promote articles written by our network of IP experts. And once again, the services are free of charge. So you're very welcome to visit the website and contact us at any time. We're there to support you. Here are some examples of materials that we have, and I selected the ones that are relevant for today's topic. So we have, for example, the IP fact sheets of mainland China, where you can find also one about Hong Kong, Taiwan, and Macau. Yes, just to answer quickly to a question that I'm seeing on the chat, the slides will be shared later with all the participants. So again, we have also a guide on enforcement of intellectual property in China, so you can consult it after the event if you want to have something in written form and a bit more in depth. And we have also a guide on how to remove counterfeit products from e-commerce websites. The China IP SME Helpdesk is part of a big family of IP Helpdesk. We cover Southeast Asia, India, Africa, Latin America, Europe itself, and we're all under the same umbrella of the European Commission, and we all offer similar services with different target jurisdictions, and of course free of charge. SMEs have used our services, for example, when checking trademark availability for their targeted jurisdiction, or to assess any registration problems that they have with their IP rights. Generally speaking, we get a lot of questions to understand the importance of IP, why it is relevant to register IP, potential risks that companies may run if they don't register their IP. So it's very important for us to raise awareness about this as well, because there are a lot of misconceptions about intellectual property, and we're there to guide SMEs to understand how the system works. We also get questions about contractual problems in relation to the supply chain, and of course also enforcement-related questions regarding, for example, IPR and infringement. We are, of course, on social media. Very welcome to follow us on LinkedIn, Twitter, and WeChat, if you're already familiar with WeChat. We promote all our events and materials and initiatives, so to be up to date with what we do. On YouTube, we upload recording webinars and some informative videos, so that's also probably useful to keep an eye on. Now, I'm happy to give the floor to Wen. Wen Song is the Executive Director of the Flanders-China Chamber of Commerce and of the EU-China Business Association. Very grateful to be working with Wen already for many years, and to always provide IP insights to the network of companies of the Chamber. So Wen will tell you everything about the Chamber and the ECBA. Wen, the floor is yours whenever you're ready.
Thank you very much, Alessandra. Ladies and gentlemen, good morning. So on behalf of the Flanders-China Chamber of Commerce and the EU-China Business Association, it is a pleasure to also welcome you to our 12th joint webinar with the China IP SME Helpdesk. It is very important that companies doing business with China also have an IP strategy included in their China business plan, and that is why every year we continue to have several sessions on IP. So as you know, China has rapidly established itself as a global leader in innovation, driving progress across some of the most transformative sectors of our time, and it now leads the world in patent filings, reflecting a deep and strategic investment in IP. From AI and 5G telecommunications to electric mobility, you see it here, renewable energy, advanced battery system, biotechnology and digital platforms, Chinese companies and institutions are really pushing the boundaries of what's possible. And together, these developments are really reshaping the global innovation landscape and shifting the balance of influence in the 21st century. We also just returned from an innovation trip with China. We went with 40 business leaders, showing them China's innovation, visiting Chinese companies, and all of them were really impressed and really noted what they could learn from China. In 2024, China ranked on the 11th place of the Global Innovation Index, published by the World Property Organization, while in 2010, China was on the 43rd place. So the speed of innovation in China is really remarkable, and many of our companies are in China for its innovation drive. They see China as a fitness center where you continuously need to stay fit as the Chinese competition is very fierce. So our companies really need to be part of this ecosystem to be able to grow on the local market, so in China, for China, but also to go global together. So being in China shouldn't be really a choice. You must take advantage of the innovation and the local market. But let me say now a few words about the role of the Flanders-China Chamber of Commerce. The Flanders-China Chamber of Commerce is set up by the largest investors from Belgium in China 20 years ago, such as Ageas, Agfa, Bekaert, Barco, Picanol, KBC Bank, Umicore. You can see them on the slide. Our aim is to assist Belgian companies to enter the Chinese market and Chinese companies to help them to find partnerships and invest in Flanders. So our activities are executed in cooperation with our structural partner, also Flanders Investment and Trade. And our aim is really to provide information, exchange experiences among our members, and share our network in China and the EU. And also these platforms, we act as a bridge, are in these difficult geopolitical times, we feel they are more necessary than ever. So besides that, we provide a weekly China business newsletter. We organize webinars on how not to do business in China. We give expert advice and receive Chinese delegations and introduce them to our member companies. We are also in charge of the EU-China Business Association, which is the association promoting the economic and trade relations between China and the EU. Today we have 19 member associations and represent more than 20,000 European and Chinese companies. We are an official associated partner of the EU SME Center in Beijing. That is a European Union initiative that provides a comprehensive range of hands-on support services to European SMEs, get them ready to do business in China. So we are there for you. I would now like to end here and give the floor back to Mr. Toby Mak, IP expert of the China IP SME Helpdesk. Thank you.
Thanks a lot, Gwen. Just a couple of words before I give the floor to Toby. Toby Mak has been our IP expert, one of our IP experts for many years now. It's a great opportunity to ask him a lot of questions. So enjoy the presentation, and whenever you have a questions, feel free to write it in the chat, and he will address as many as possible at the end of his presentation. Toby, I'll leave the floor to you. I'll also leave you the space to introduce yourself. You have such an interesting background, and yeah, enjoy the training, everyone, and thanks a lot, Toby and Gwen, for organizing this training with me.
Thank you, Alessandra and Gwen, and let me share my slides. Give me 1 second to start the slide. So I hope everyone could see it. If you have any problem, please let me know. And today I'm going to talk about enforcement of IP in China. First, a little bit introduction of myself. My name is Toby Mak. I am a registered Chinese patent attorney working for the Chinese IP firm T&How Intellectual Property Attorneys. But in addition to that, I've been doing a lot of work for two IP organizations mainly. They are the AIPLA, American Intellectual Property Law Association, and the IPO, Intellectual Property Owners Association. If you're interested in any of these organizations, please let me know. And I was born and educated in Hong Kong, and I spent my entire life in Hong Kong before I joined the firm in 2010. But then I moved back to Hong Kong in 2014 and start from there to work from home. And if I'm not staying in Hong Kong, then I'm traveling. So this is the formal introduction of myself, which is not that interesting. And about T&How, we have about 230 people, about 82 patent attorneys, 15 trademark attorneys. Most of my colleagues are in Beijing. But as I said, I'm the only one working in Hong Kong. So this is the more interesting introduction of myself. For some reason, before I went to the university, I did a year of database programming. So even though I'm a chemist, I'm still working on quite a lot of computer-related inventions. And as I said, I now work from home in Hong Kong most of the time. And I am the well-known troublemaker at IP conferences. If you look at my initials, you will know what I mean. Luckily, I'm not the famous Christian rock star Toby Mak, because you will not like me singing. I'm an addicted gamer and a comic and anime lover. And if you know all of the above, I'm sorry about that. Now, let's start with enforcement of IP in China. Unlike most other jurisdictions, in China, IP enforcement could be enforced by judicial and administration. Specifically, I mean through civil cases and through administrative cases. And enforcement of IP in China is done under a bifurcate system, which is the infringement and validity are separately tried. That is, during an infringement case, only whether the infringement of the IP would be determined. The IP itself is invalid or not is not a proper defense in the infringement case, while the validity of the IP would be tried separately. And for invalidation, it is done at the CNIPA, which now handles all the trademark and patents in China. While the infringement, they are either handled in courts or in local administrations. In courts, they are the civil actions, and in local administrations, they are the administrative actions. What does invalidation do? Invalidation may suspend infringement trial, which I will explain later. Remember, this is only may, not always necessary, that invalidation will suspend infringement. There is one characteristic that we have to note is that the courts are overwhelmed, and they have a high tendency to push cases away. What do I mean by overwhelmed? These are numbers of the Beijing IP Court, one of the busiest IP court in China. They have received about 2,000 cases a year, with about 100 judges, and most of the cases have to be tried by 3 judges. You do the math. That is not a pretty picture, and that explains why courts have a high tendency to push cases away. Exactly how they do it? They require very high level, very strict formalities to be complied to in order for them to take your case. So if you go there casually and try to say, hey, I got infringed with not well prepared documents and evidence, they will just say, no, I'm not going to accept your case. Please try again. This has happened many times, and that is why if you do not use someone who has done it before, you would find your cases being rejected by the courts very easily. On the other hand, the administration, particularly for patents, it seems that they want the infringement business. And why I say particular for patent infringement cases is because patent infringement case handled by the administration is new. It is only introduced in 2020. Is introduced in the 2020 Chinese patent law, which is the 4th revision, and put into force in January 2024, which I will explain to you my experience of one case. Now, these are the differences of judicial and administration enforcement of IP in China. For judicial, the civil cases, the courts only accepted both registered and non-registered IP. It is expensive to file such cases, which is about 1.5 million RMB minimum. However, compared to other jurisdictions, particularly the US, 1.5 million RMB for enforcing a patent case is not expensive. By the way, this 1.5 million is for patent cases. If it is for trademark or design cases, that would be a lot cheaper, say about 0.5 million RMB. The courts could grant injunctive relief and damage awards. However, the court actions typically are slower, which after they accept the case, the court would take about 9 to 16 months to give you that decision. Again, however, this slower is compared to administration compared to administrative action in China. Compared to the action in the US, this is a lot faster, because in the US, it could take about 3 to 5 years to get the first decision out. On the other hand, for administration, the administrative enforcement, they only accept registered IP, which I will explain later, and it tend to be cheaper. The most expensive cases we are talking about, patent cases, we are talking about 500,000 RMB. And again, it would be a lot cheaper if we are talking about trademark and designs and copyright, or relatively simple patent cases. However, the administration can provide the patentee with only the injunction relief only. They will not be able to provide any damage awards to the patentee, even though they could impose fines on the infringer. However, the result of the administrative cases could be used later at the civil action to claim the damage award. It is very fast, particularly compared to the court actions. It takes only about 3 months to get the decisions, which is factual because that's my experience in my case anyway. The next thing I need to talk about is what is the infringement environment in China. Well, you see a very cozy panda lying around, and you see the big word fake. What do I mean? Well, these are the major Chinese. These are the characteristics of most Chinese infringers. They are lazy, they are cheap, they are not well advised. And if you think about their nature, that makes sense, because if they are not with these qualities, they would not like to be infringers from the start. And because of these characteristics, these infringers tend to produce products that look exactly the same as the original one, but do not work well. In some cases, these products may not even work at all. And therefore, what the IP tools need in such environment, dealing with such lazy and cheap infringers, they need to be ground quick, and they have to be pictorial. And in particular, we need registered IP. Non-registered IP are difficult to enforce. If you forget anything, what I say today about Chinese IP environment, please remember this. If you want to be protected, you need registered IP. So what types of intellectual property are we talking about that are available in China to protect you? And this include trademark, copyright, design, utility model, and invention, utility model patent and invention patents. The time needed in this slide shows the time needed for you to get the registered IP, which for trademark, copyright, and design, they are not long. Utility model also not long, but for invention patent, it could be a lot longer. However, depending on whether PPH, patent prosecution highway is used, invention patent could also be granted relatively quickly. Now, what are the characteristics of trademark, copyright, and design patents in China? As the previous slide shows, they tend to be granted quick, and they are easy and comparatively cheap to enforce. Why? Because most of the time it involves only the visual comparison of the registration with the infringing goods, whether they look the same or not. And there is one thing that could be useful for these 3 types of IP rights in China, is that they could be registered at the Chinese custom to stop export. But again, the Chinese customs would only entertain registered IP in China for such recordal. And why this is worthwhile mentioning is because unlike the customs in the other parts of the world, for example, in the US, Germany, or in Europe in general, the customs in these Western jurisdictions, their major job is to stop infringing goods from coming into the respective jurisdictions. However, in China, the Chinese customs is there to stop the infringing goods from getting out. Exactly what is that? I have done a study about 10 years ago. It shows that the Chinese customs, what they did is 97.5% of the seizure of the infringing goods are goods trying to get out of China. And all these 3 types of IP rights, as I said, they are good to stop dupes, that is exact duplication of the original goods. However, they're relatively easy to get around and could become toothless when facing more sophisticated infringers. Specifically, if the infringer change the look of the product to a way that it looks different, then they get away with it. Utility models in China, on the other hand, they also can receive quick grants, but compared to trademark, copyright, and design, they are more expensive and difficult to enforce. Specifically, we need to have a patent specification ready for filing at the at the very first. And then when during enforcement, we need to obtain a so-called patentability evaluation report from the CNIPA in order for the court or the administration to accept our case. The advantage is it is more difficult to get around if the patent specification was well drafted. About this topic, please talk to your patent attorneys that represent you, because this is something that could be quite complex. And as I said, enforcement relies on after-grant patentability evaluation report, which has no control. Exactly what is this report? This report is like a typical patent examination report, but the patentee have no way to respond to. That is, once the report is out, that said the utility model is not good due to whatever reason, the patentee is then stuck. There is not much the patentee could do to revive the case. For utility models, the infringement case generally would not be suspended, even though the invalidation petition is accepted. However, the recent trend is that utility models seems to be discouraged by the Chinese government. First thing is, seems they are cracking down a lot of on people filing utility models, accusing them of filing so-called abnormal applications. And the numbers of utility models get granted and get filed in China has been dropping in the last 3 years. Invention patent, on the other hand, they tend to grant slow, but as I said, there are ways to accelerate the grant of invention patents. Invention patent is the patent that is equivalent to a European patent. However, even though it could be accelerated for grant with proper measures, it is still, among all of the IP tools available, this is still the one that is slowest to be granted. Compared to trademark, copyright, and design, same as utility model, they are more expensive and difficult to enforce, and more difficult to get around if the patent specification was well drafted. However, unlike utility models, the enforcement of invention patents do not require a patentability evaluation report, because such patents have gone through what we call substantive examination. Infringement cases would generally be suspended if invalidation petition is accepted. Now, for administrative IP enforcement, in fact, it has been long existing, but it has been only available to trademark, copyright, and designs only. Patents, utility model, and invention patents, they only joined this game for less than 2 years, less than 18 months. And the difference is that for patents, including utility models and invention patents, the law requires that the infringement case have to have nationwide influence. However, what I found, the standard is pretty low for the local administration to accept the case. Specifically, online sales is enough, because online sales would make the infringement available nationwide. And as I said and explained earlier, maybe, such administrative enforcement cases, they are handled by local IP administration. What I mean is, if the case is, if you file the case with the Zhuhai in Guangzhou, in the Guangdong province, for this administrative case, then this case would be handled by the Zhuhai IP administration, the local one. The good thing is that since administration is competing for business with the courts because it is relatively new, and these administrations, practically none of them have any experience in dealing with such cases. But so that your cases could be accepted relatively easily, and the progress would be very fast. However, there is one thing that I found which is quite discouraging, is that there's a strong local protectionism exists. Particularly, if you are a foreign patentee, then you are bound to file the case where the infringer resides. Now, you imagine if you file the case in the place where the infringer resides, the infringer tend to be a significant taxpayer in that jurisdiction. And for the local administrations, even though they may not hear any words from others, they could face the pressure because they may have someone working for this infringer. And when I say about they could be a big taxpayer in the place, we could be talking about they are hiring, let's say, a few hundred people or maybe even thousands of people in that place. So you can imagine why the administrations tend to be more protective of these local infringers. However, such local protectionism could be resolved by complaints to the e-commerce platforms. Specifically, how we do it is what we found is when we file a complaint to the e-commerce platforms asking them to take down a sales link of infringing products, these platforms either tend to not listen to us, not doing the takedown, or they take down the links, but once they receive the complaint from the infringer, they would restore the link shortly thereafter. And the excuse is that, hey, we do not know whether there is actual infringement. If you have a decision from any authorization like the court and the administration, then we will entertain your request to take down the links. This seems to be bad for the patentees, but in fact, this is good in this scenario because then it makes the e-commerce platforms a co-defendant in the case. And there's a high chance that these e-commerce platforms, their headquarters or their representative office may not be within the same city or province or even province of the infringer. And that is one way to allow us to choose the litigation platform. This is what we call foreign shopping. So what we need to do to file such enforcement cases, these are the case acceptance requirements. We need notarized and certified power of attorney. Luckily, legalization is no longer required. If you have done legalization before, you will understand why I'm so happy with that requirement gone, because there's a process that you do not want to go through. Specifically, you need to bring your notarized power of attorney to the Chinese embassy in your jurisdiction to get it legalized. And it could be a long waiting process. I have clients that took 2 months without any progress. And we need a certificate of good standing issued by the patentee's local company registry. Again, this is not a big issue to get this document. Then we need the evidence of infringement. But the catch is it has to be notarized by a Chinese notary. Do not buy your own infringing goods and send it to us for filing with no matter the court or the administration. It would not work. We need to do the purchase in China and have that witnessed by the Chinese notary. And we also need to prepare an explanation of infringement for patents, typically in the form of a claim chart. The power of attorney and the certificate of good standing need Chinese translation if they are not in Chinese, but this could be done relatively easily. Time to get A to D ready. Well, it took me about 2 to 3 months for my case that filed last year. And I will talk more about that later, in the later slides. They could be shortened if streamlined, let's say 1 to 2 months, but it takes time. Once accepted, the hearing arranged in 4 to 5 weeks, and the case decided within 3 months from the date of acceptance by the local administration. The case I did last year, I filed the clients gave me the instructions in early April. We were able to complete all the materials preparation and as I explained above, and file the case in about mid of June. Then we heard back from the administration in about actually early July that they're going to hear our case by the end of July. And we got our results before the end of August. I mean the decision. So what are the overall costs? Well, first we need the client. It is a good idea to do an on-site investigation. Why is that necessary? Because it is necessary to evaluate the worthiness. There are cases that we found, okay, there's a big factory of, let's say, 500-600 people, which is the case that I found. But we could also find, hey, this is an empty office. This is just a shelf company. And if it is a shelf company, does it make sense to go after the infringers? That's why this money is used to do the on-site investigation before filing the cases. Then we need to prepare the claim chart. Then the cost is about 3,000 to 5,000 US dollars, and we would need to arrange a notarized purchase and get all the things together to file the complaints physically. There's no way at present for the administration, we need to actually fly over to that place to hand over all the materials we prepared physically in order to file the complaints. Then we have to attend the hearing, which typically is one morning or one day. Then we report the decision. The expenses, they include fees to the notary publics, traveling, and accommodation and disbursements. Now, this is the exact evidence that we filed in the administration case. You can see it is well sealed with notary seals all over the place. And all these seals are important. If any of these seals are broken, the administration will not accept our case. Why is that? Because the excuse would be, hey, we do not even know where do you buy these products, and whether these products remain the same, and you do not exchange it with your own products, which definitely would infringe. I mean, the patentee's product. That's why we need it to be sealed like this. And that's the major part of what the Chinese notaries are doing. And as I said earlier, for foreign patentees, they have to sue at the infringer's residence. And they are the typical they provide significant contribution to local tax. The advantage of administration case is they're quick and cheap to sue. You will probably find the results very quickly. And another good thing is the administrative decision has no estoppel to civil action at court. In fact, for the cases that I filed last year, it got a bad result. That is, the administration found the infringer to be not infringing, but in a way that I do not agree at all, because I found they tried very hard. The local administration tried very hard to try to give an excuse for the infringer to get away with the infringement. And that is why subsequently, my client decided to file a civil action at a court which is not close to the infringer residence by bringing the online sales platform as a co-defendant. And the materials and information collected could be used in the civil actions to significantly reduce the cost. So a good suggestion my suggestion of doing infringement, particularly for patents in China, is to first file an administrative IP enforcement case at a place where the infringer do not reside, see the results, and the results are good, then of course you can use it to stop the infringement. But if it's not good, then file a civil action at the court. And because of the need of foreign shopping, it is advisable to first file the complaint to online platforms in order to allow us for foreign shopping. Now, the civil enforcement, the requirements, in fact, they are the same as the administrative enforcement, but they tend to be slower. Like the civil action that I filed, they were filed in November last year. I received a notification that the court planned to have a hearing in April, but then it was suspended because the infringer filed an invalidation request, and that's why the case was suspended. Then we got the positive positive invalidation results if I remember right, is in May. Then the courts should restart the case, but then it took the courts about another 2 months to arrange the hearing, which the hearing is now supposed to be held in August. Hopefully, they will not delay the hearing again. And as I said, we filed this civil action at a court which is distant, which is not at the place of residence of the infringer. And unlike the IP administration, in which for one place there's only one IP administration to handle all the trademark, design, copyright, and patent cases, the trademark and design cases tend to go to a different court. They are now handled by the local intermediate court, while patent cases, strictly speaking, they should also be handled by the intermediate court at the local level. But there are now specialized IP courts. They are now in Beijing, Shanghai, and Guangzhou, and there are a lot of local specialized IP tribunals to handle such patent cases. The cost, as I said, could be 5 to 8 times of administrative cases, but if you do both, cost could be reduced significantly. This is all for now, and I would like to leave some time for questions. I saw one question asking how many cases per year do you handle? Personally, I handle about infringement case at most about 1 to 2 per year, because they're very intensive. They spend a lot. We have to spend a lot of time on each case. And is there a trend of increasing and decreasing? I would say that I do not have a good sense of it because of the limited number of cases that I receive. But my observation is that whenever there's an economic downturn, people tend to litigate, tend to sue more. Why is that? Because in good times, the market may be bigger and people may not be too irritated if the market shared or the market got eroded by the infringers. However, during bad times, you try to take away even a small percentage of my share, I will go after you. That's the way of thinking. And how many cases do successful enforcement IP rights? Well, actually, it depends on the preparation, and depends on whether the patentee is determined to go after the infringer. If you go after long enough, if you go after hard enough, you will get something. If you don't, you will get nothing. I've seen people give up a lot of times in between, even before they filed the case with the administration or the courts, and all those abandoned attempts, they would not reflect in the statistics. However, if you look at the court statistics, in fact, the Chinese IP system is pretty right holders friendly. What I mean is, if you're the patentee, if you're the trademark registrations owner, if you're the design patentee, then you will find yourself being winning most of the time. Specifically, almost like 75% of the time. Why is that? Because as I said, the infringers are lazy, but it requires the right holders to actually spend the resource, spend the time, and spend the effort to go after the infringers. There's another question about nationwide influence. Aquaculture sector for which there is activity in specific regions only. Well, you mentioned there are activities in specific regions only. That means there's not only in one single region. And according to this, it seems to me that there is a chance that we could go after the infringer by administrative IP enforcement. Of course, it depends. For example, if these activities, they are like only building factories in local specific places, and the products are not being sold in China nationwide, it may be difficult for the administration to accept that it has nationwide influence, or the infringement amount is pretty small. So I'm sorry to give you a lawyer answer. It depends. The next question is, are there certain industries more affected than others? I would be grateful for further elaboration of that. My way of reading is that whether there are certain industries that are more affected by the others with respect to IP infringement. Well, there are particularly the consumer markets. If you look at, but in fact, IP infringement comes across all different areas of industries, even from pharmaceuticals to consumer electronics, cosmetics, liquor, you name it. But there's one thing that I find that the Chinese government is very sensitive, is if the infringing goods involve product safety, that is what I mean is they are not safe, then the Chinese government would be very unhappy and they would go after such infringers quite vigorously. We may not even need to go after them with civil actions or administrative actions at all. So if my understanding is incorrect, please tell me, please elaborate. What do you mean by are there certain industries more affected by the others than the others? So the next question is the products are being sold B2B. This makes purchase of evidence accompanied by a notary almost impossible. Are there any solutions for this? If it's only B2B businesses, actually one way to do it is that's what we have been doing, is to get the other side to give us to sell us some samples. Of course, we use investigators to pretend that they are biased, they are business biased, and then we use that investigator to try to buy some samples from the potential infringers. And during this purchase process, of course, we will get the entire process notarized. In some cases, that may work, but it also depends on whether the competitors are very careful in giving away samples or engaging into new businesses. Sometimes we may not be able to get the evidence. In such cases, we may still be able to use certain other evidence to establish your case, particularly, and then present the case to the court and see how the courts react. And if we have sufficient evidence to show that, hey, this has actually happened, for example, with some public information that, oh, there's a big purchase from your client, from your competitors, but this purchase and the evidence is available only to the competitors only, then the court may still accept such a case and then go to court to try to get the evidence for you. But this is not typical cases. Would you have any specific recommendations regarding GI enforcement? I believe GI enforcement refer to geographical indication. This is the same as other. This is a little bit different from other registered IP, and because the right owners tend to be, if my understanding is correct, tend to be a local jurisdiction or a local association. So, but other than that, I do not see there is any other specific difference from enforcing geographical indications than the other forms of IP rights. Have I answered all questions?
Yes, for now it seems that there are no more questions. Thanks a lot, Toby, for your valuable time. I think my understanding is what we have among attendees, entrepreneurs active in different sectors. So my suggestion is already during the registration, in the registration form, some of them have required to be contacted by the IP business advisor, and I'll follow up with those people in particular so that they know how to book a meeting with us. Also, I will follow up with everyone who attended today. I'll be sharing the slides. And I will share also contact information. So in case you have any follow-up questions, we're happy to take it from here. Of course, you also have the contact email of Toby Mak in case you'd like to have his assistance. But for any general question, we're happy to also to take it from here. If there are no further questions, I think we can finish here. Thanks a lot, Toby, for your excellent presentation and for, clarifying a lot of important matters about IP enforcement. And thanks again, Gwen, for reaching out and for working with us. It's always a pleasure.
Thank you very much, Alessandra. It was a pleasure together too. Thank you.
And yes, have a good day. And until next time. Bye-bye, everyone.
Goodbye.
Bye-bye.
Bye.